I am chairing this morning because our chairman has had a death in the family and is unable to be with us. So she will continue to be in our thoughts and our prayers, and we extend our condolences to her. I have some preliminary announcements. As you all know, the First District Court of Appeal has graciously allowed us to be here, and we want to respect their rules, and those rules are that absolutely no food or beverage other than the water that has been placed at your dais is allowed in the room. And I would ask you all to please silence your cell phones. Those of you who choose to address the commission, please speak up so our recording equipment can pick you up properly. And to my fellow commission members, please speak into the microphone so you can be heard. And I would ask you to be as brief and concise as possible in your questions and your comments, as we have a number of items for consideration today, although I think our agenda will move rather quickly and should not be a lengthy meeting. Pursuant to Section 286.0114 of the Florida statutes, members of the public have the opportunity to have input on matters before the commission during this public session. This means that the public can have input on matters other than complaints, opinions, determinations, and financial disclosure cases. If you desire to be heard on a matter, I will recognize you, but I ask that you fill out a speaker card and give them to Mrs. Fulford, who is sitting in the back of the room with her hand raised. So with that, we will proceed, and I will ask that the roll be called.
Commissioner Akers?
Here.
Commissioner Cardinal?
Present.
Commissioner Cummings? Here. Commissioner Bates?
Here.
Here.
Commissioner Grant?
Yes.
Commissioner Ledesma? Commissioner Meggs?
Here finally.
We have a quorum present.
All right, thank you. We do have a quorum. All right. Let us stand for the Pledge to Allegiance. Commissioner Gilzine, if you would lead us.
Absolutely. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The next item on the agenda is the approval of minutes from the previous meeting.
I move the
Any
approval.
discussion? I'm sorry, Commissioner Akers?
I just wanted to move the approval.
Okay, is there a second? Second by Commissioner Wallman. All in favor, say aye.
Aye.
All opposed, say nay. All right, this takes us into our main agenda, and that is the consideration of final action regarding pre-probable cause stipulations. The first case that we have is in Ray Jackie Toledo, number 20-206. Will the parties please identify themselves for the record?
As for Representative Toledo.
Elizabeth Miller, advocate for the commission.
Okay. We have before us a pre-probable cause stipulation between the commission advocate and the respondent. And after considering all the materials and the representation of the parties, the commission may move to approve or reject the stipulation. As this is a pre-probable cause stipulation, if the stipulation is rejected, it will go immediately to the probable cause determination. Complainants have the right to respond in writing to proposed stipulations, but no responses were filed in this matter. Ms. Miller, you're recognized.
Thank you. Good morning, Commissioners. In this case, the
Could you pull
respondent...
your mic down a little bit, please?
Yes. In this case, the respondent is a sitting member of the Florida House of Representatives. There are 3 allegations. In the first allegation, the respondent failed to disclose profits from the sale of real estate. She admitted to that violation. That occurred in 2017. Second allegation involves her 2018 CE Form 6. She failed to attach the necessary addendum listing assets to this particular form. The respondent admitted that allegation also. As far as the third allegation, I'm asking for no probable cause. That allegation was not substantiated by the facts of the case. You will notice in this case that there is no recommended penalty or a penalty. That's because for sitting members of the House or the Senate, this commission, if you adopt the joint stipulation or the pre-probable cause stipulation in this case, the case goes over, the stipulation along with the investigation goes over to the appropriate chamber, whereupon either the Speaker or the President will assign the case to the appropriate committee for further investigation and to resolve it with a penalty. If the committee over there in the House or the Senate requests that this commission give it a recommendation for a penalty, the statute says that you shall do so. As far as the case is involved before you, we recommend that you adopt the pre-probable cause stipulation. Thank you very much.
Are there questions of members of Ms. Miller? Thank you very much.
Thank you.
Counsel for the respondent?
We would just urge you to accept it. There's not much I can add to it. It's a very straightforward case.
Are there questions of respondent's counsel? Do I hear a motion?
To accept the recommendation.
Commissioner Carvajal moves to accept. Is there a second?
Second.
Commissioner Anker, second. All in favor, say aye. Aye. All opposed, like sign. Show it adopted. Thank you, sir. The next case is, if I can get my mouse to work right. In Re Reginald Sessions, case number 21077, and I will not repeat everything I said regarding the last one because everything applies except there's a different respondent. Mr. Heron, you're here.
Mark Aaron on behalf of Reggie Sessions.
Ms. Miller, you're recognized.
Thank you. Commissioners, this is also a pre-probable cause joint stipulation. After the respondent's tenure as a Fort Pierce City Commissioner ended, but before the 2-year lobbying prohibition ended or ceased, this respondent appeared before the City Commission and advocated for his client as a lawyer. And I would like to be clear that the violation is for appearing before the City Commission. This commission has found that sitting before a planning board or representing an entity before the planning board within the 2-year period after you leave office is not a violation. In the joint stipulation, the respondent admits the facts in the report of investigation and has agreed to pay a $1,000 civil penalty and agreed to a public censure and reprimand. And the parties request that you adopt the pre-probable cause joint stipulation. Thank you.
Are there questions of Ms. Miller? Not appearing. Thank you. Mr. Heron.
As Mr. Coates did, we would urge you to adopt the joint stipulation, and I'm here to answer any questions you have.
Are there questions of Mr. Heron? Do I hear a motion?
Move the adoption of the pre-probable cause joint stipulation.
Commissioner Ankers moves approval. Is there a second?
Second.
All in favor, say aye.
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 All in favor, say aye.
Aye.
All opposed, like sign. Thank you, Mr. Aaron. Okay, the next item is consideration of final action, pre-probable cause, joint stipulation, Melody Gerardo, case number 19-120. Ms. Miller, you're recognized.
Thank you. Elizabeth Miller, advocate for the commission. This case was referred to DOA for a 2-day hearing, but the morning of the first hearing, the respondent decided to enter into a joint stipulation. In the stipulation, she agreed to the violation or admitted the violation, and she agreed to a public censure and reprimand and a $5,000 civil penalty. And the parties would request that you adopt the joint stipulation. Thank you.
Are there any questions of Ms. Miller? Commissioner Ankers.
I don't know if you're at liberty to say or if it's even appropriate, but I just wonder when someone waits to that moment after you've gone through that preparation, if it affects the content of the joint stipulation.
If I may, it does in my opinion, yes, ma'am. We were prepared with all of our witnesses. They were in the waiting room for Zoom, and the respondent decided not to go forward. So in my mind, it does cause an enhanced penalty.
So that's reflected in this?
Yes, ma'am. Yes, ma'am.
Thank you.
Are there further questions? Commissioner Meigs.
Yeah, I just have a question. When we have a stipulation for a public censure or reprimand, who does that? I should know that, I guess, but I don't. What happens?
If I may, the commission sends the matter to the governor, and the governor issues it in an executive order.
Are there further questions? Commissioner Gates.
Thank you, Mr. Chairman. This case certainly had a lot of permutations and claims and representations and misrepresentations in it. And I'm just wondering, given the long list of misrepresentations, how did you happen upon the settlement that you arrived at? Where was your pain threshold? Why wasn't it more, or why wasn't it less?
Through the chair, the morning of the hearing, I'll be quite frank with you, the respondent was not prepared to go forward. He forgot about it. It wasn't calendared. So I don't know what happened on that end to get her to agree. She had been insistent prior to the morning of the hearing that she was not going to enter into a stipulation. However, I recall that this was a contested issue before the commission. It wasn't straightforward. It wasn't a 9-member vote for probable cause. And I thought that this was appropriate due to the division with the commissioners, and it was a little more than, well, actually, it was a lot more than I had initially requested for a joint stipulation, and that's because we were prepared to go to hearing.
Mr. Chairman?
You're recognized.
This is, I guess, just a procedural question then. So the fact that there was lively debate and not a unanimous vote on this commission influenced you in how to proceed with calculating the amount of the fine and the other aspects of the stipulation?
Through the chair, yes, it did, because I know that there were commissioners who did not believe this was a violation.
Thank you, Mr. Chairman.
Are there further questions? Commissioner Gilzine.
Good morning. If we decline this because of the fact that commissioners currently want to increase the penalty, what would be the process? I guess that's a question for our executive director.
Well, I mean, we're here to accept or reject, and if we reject, then it goes back to where we were.
Right?
Through the chair, yes, the parties could go to DOA and have a full evidentiary hearing, or they could try to reach terms of another settlement agreement to bring back before you.
Are there further questions or comments?
Mr. Chairman?
Commissioner Gates?
Not meaning to prolong the agony, and I grant that I'm a more junior member of this commission, but I would ask more senior members maybe to help me with this, and ask the executive director, do we mean to say that even though there's a definitive finding and a decision by this commission, that if there's a split vote, if that somehow waters down how we will proceed post that vote in penalty, in assessing a penalty or arriving at a settlement? That seems to be somewhat amazing to me. I'm used to serving on boards and commissions and in the legislature where, a vote's a vote, a W is a W, an L's an L.
Well, Commissioner Gates, my response, and I'll certainly defer to our executive director if she disagrees with me, but I well recall this case. We debated for a long time. This is before you were on the commission. It, I guess, was certainly more than a year ago, maybe a year and a half ago. Commissioner Cummings was not on the commission at that time. Commissioner Wallman was not on the commission, and I don't think Commissioner Ankers was. So this is somewhat a case of first impression for a lot of us. This was a very high level. I happen to be from Tampa, and so it received an awful lot of comment in the press. And we debated, I suppose, for an hour on this case, and it was adopted by one vote. It was not unanimous. It was not near unanimous. It was a 5-4 vote, as I recall. But my understanding of rules is just exactly as you say. It's kind of like getting elected to office. You either win or you lose. Whether you win by 99% or 51%, it's a win or a loss. And the decision of the commission was that we found probable cause and we moved forward. And there are really two options when that happens. One is the parties are free to enter into some kind of a stipulation that the petitioner and the respondent, and as I recall in this case, there were, 7 petitioners, something like that.
There were, I believe, in the 20s, 18, something like 18 to 20.
We consolidated all of those because they all were about the same thing, but there were just many petitions. And, we voted to find probable cause, and the parties moved forward, and now it's back before us because the parties, and I don't think there's anyone representing the respondent here. I don't see anybody out in the audience. It moved to the point of a stipulation, and there are various reasons why people enter into stipulations. One is they just want it to go away. One is they don't want to go through a DOA trial. One is they feel like it could be worse than what they could agree to stipulate, but for whatever reason, they enter into stipulation. And when they do that, instead of going to DOA, it comes back to us, and we can accept or reject it. And if we accept it, it's all done, and the fine is paid, and the reprimand is issued, and so forth. If we reject it, it goes back where it was when it went out of the commission the last time, and one of two things can happen. They can either renegotiate and come up with a stipulation, or it can go to a DOA trial. So, that's where we are, and I think Commissioner Gates and the rest of you who are now, I guess, a majority of the commission who were not here, who did not have the benefit of hearing the lengthy debate, it somewhat puts you at a little bit of a disadvantage because this is something totally fresh to you, and something that was subject of great lengthy debate, and as I said, only passed out of here by one vote.
Mr. Chairman, just a final comment. I understand the reasons why the respondent would want to move to stipulation, and my understanding as a non-lawyer is that one of the reasons that we might move to a stipulation is because we feel as though it might be the best way to bring resolution to a case that we might not otherwise win before DOA. What I was, I guess, questioning was how it came to be that just because there was a lively debate on the commission, and just because it was a split vote, that therefore that would influence how we would proceed in arriving at a settlement. But I don't wish to prolong the agony, but it is it's a nuance of the decision-making process that I've been unfamiliar with until today.
And I don't know, Ms. Miller, you may want to comment on this. Usually, any case we have, it's a one-on-one. We have one person who files a complaint, and we have another person against whom the complaint is filed. You know, and here, what'd you say, 18?
Yes, sir.
18 different complaints were filed, all alleging more or less the same thing, and we chose to consolidate them. So when there are that many petitioners, I don't know how you arrive at a stipulation. I think it's more an admission where the respondent has said, you know, I'll agree to pay this money and have a censor to make this go away. So it's different than most situations where there's an entry of an agreement between all the parties.
If I may, through the chair, this case was somewhat unique in that, as Commissioner Grant said, it was a lively debate, and I did take the opinions of the commissioners into account when I asked for $5,000.
All right, are there further questions? Commissioner Ankers?
If there hadn't been lively debate, can you suggest what you might have made the recommended penalty?
If I may, probably $10,000. As I said, we were ready to go. This case had been continued numerous times by the other party, and if there hadn't been such a split, I think I would have asked for more, maybe $75,000. I beg your pardon, holy moly, 7,500. Probably I would not have asked for 10,000. But that's sheer speculation.
Mr. Chairman,
Commissioner Gilzine.
I'd like to make a motion to reject the stipulation in order for our I don't have my notes. Advocate to go back and come back with a penalty that is more in line based on the Congress questions I'm hearing. It sounds that there are commissioners who would want a stiffer penalty to come before us. So I make a motion to move forward with that.
Oh, okay, and
To reject. So we have to reject.
okay, and just to explain, as I understand your motion is that if it passes, then the stipulation is rejected, and it would be up to the advocate to meet with the respondent and say the stipulation you agreed to has been rejected by the commission, and you now have a choice of entering into a new stipulation with a higher penalty or electing to go to a DOA hearing.
Correct.
All right, is there a second to Commissioner Gelzine's motion?
Second, with full faith in the advocate's ability to try the case at DOA.
Thank you.
All right, is there discussion on the motion? Commissioner Carvajal.
Thank you, Chairman. I would echo your earlier comments first that, you know, whether something passes by one vote or unanimous, it is our posture regardless, and most of us would stand behind those positions. So while I appreciate the advocate recommending that the debate influence the number to accept and stuff like that, I'm not sure that that's always something that the advocates would have to represent. That said, what I'd add to the particular motion that's at the table is if I would remind the commission that the respondent has already resigned from office, which would have been potentially the ultimate extreme of the penalties that we could have exerted in this case. This was for publishing something on a website. The long debate was not whether, in part, was long because we were discussing whether those credentials really were suitable or not, as being represented that way or not. So the debate was about the credential, not necessarily about the respondent's particular actions or intensity of actions, if I remember the debate correctly. And I would actually reject the motion that's on the table and support the stipulation as it is.
Okay. Is there further discussion? Hearing none, all in favor of Commissioner Gelzin's motion that we reject the proposed pre-stipulation and refer it back to our advocate for further negotiations and other action with the respondent. All in favor, say aye.
Aye.
All opposed, say nay.
Nay.
Show the motion adopted. Okay, the next case is Tracy Davis, 20-211, consideration of final action post probable cause. Oh, I'm sorry, I skipped down too far. Yeah, case number 2125, Muhammad Amin. Ms. Hadley, you are the advocate. Is there anyone here representing the respondent? Ms. Hadley, you're recognized.
Thank you. Respondent was a candidate for State Representative District 96. The commission found probable cause to believe that he violated Article 2, Section 8 Florida Constitution and Section 112.3144 Florida statutes by filing an inaccurate 2019 CE Form 6, full and public disclosure of financial interests. Through settlement negotiations, the parties have come to an agreement. In the stipulation, the respondent admits that he violated the aforementioned Code of Ethics and agrees to the entry of a final order recommending a civil penalty of $1,000 and public censure and reprimand. I respectfully ask for the commission's approval of the stipulation.
Are there questions of Ms. Hadley? None appearing. Is there a motion that we approve the pre-stipulation?
Mr. Chairman,
Commissioner Gates.
prior to a motion, let me make my usual disclosure with respect to Senator Ehrenberg and Ms. Plymile, my having served with both of them in various capacities, but in my judgment, not affecting my actions on this matter.
Thank you, sir. Any further comments? Do I hear Commissioner
Chair.
Waldman?
Thank you, Mr. Chair. We see a lot of these types of cases, and I think we really need to be a little bit more I think the penalties should be a lot higher than what we're doing, because these types of things that get done impact elections. And we previously, and we have before us that another matter coming up shortly, similar, that actually affected the outcome of a race. And some of these do too. And I think we really owe it to the state of Florida that we hold these people really accountable for what they're doing, which is changing, in many instances, the way an election will come out. And a lot of these people who just file as write-in candidates, they're doing it at the last minute, but they should be more diligent. And when they're not diligent, I think we have to hold them accountable. I think $1,000 is not a sufficient amount of money. I think we really need to fine these people more to where it really gives people pause to think whether or not they're going to file as a write-in candidate and impact elections. Just my opinion.
Okay, are there further comments? Do I hear a motion that we adopt the stipulation?
Mr. Chair, with full deference to Commissioner Waldman's comments, I will still move to accept the stipulation as presented.
Is there a second?
Second.
Commissioner Ankers? All right, all in favor, say aye.
Before discussion.
I'd like
That's
to-
good, yeah.
Yeah.
Mr. Chair, if I could say one other thing. And I agree with Commissioner Carvajal in this instance, because I think we need to give direction to the advocates. So my position is, in future ones that come before us,
Okay.
to me, $1,000 is not sufficient. So because you brought this one, I will support this one right now, but I will say, in the future, I will not support $1,000 because I don't think it's sufficient. I think we really have to hold people accountable.
Well, I think that's well said, and personally, I think it goes a little further than what you have said. My concern is there needs to be a bigger bite out of the apple in a number of cases, not just election cases. I think that people need to fear the penalties of the Ethics Commission, not considering it just a cost of doing business, which is what you're really saying, Commissioner Waldman. But it's not just on election matters. I think it's on all matters, or most all matters. Commissioner Carvajal.
Thank you for discussion. First of all, I appreciate the comment. All I'll do is remind folks of the advice I got from other commissioners when I first joined, and that is sometimes if the fines are too high, they languish when they leave beyond our reach in the ultimate enforcer's offices, in this case, the governor or the legislature. And that's why some of the things don't ultimately ever get collected or pushed. So that was one item. But the other, to Commissioner Waldman's point, we have humans listening to these stories so that we can understand the intensity of the situation. There are other cases, for example, on today's dockets that may on face look like they're the same, but they're not. And that's why we debate these items. And I'm not sure that $1,000 for something that is a reporting error that is pretty common is the case. I, for one, worry more about the writing candidates and the strategies at the electoral process, but that's not what we're seated for. So I would probably oppose too high of a penalty ultimately, but that's why we work together on these things, and I appreciate the opportunity to debate these things. I think the amount that's here in this case is reasonable.
Mr. Chair.
I didn't know if the executive director was alienating me and moving away, or
We're actually all moving.
everybody's I rescind that last comment.
Before I call for the vote, is there anyone who wishes to make any public comment?
I just wondered if the advocate had any input based on this discussion and your recommendation.
Only that, as has been stated, there are different levels to when someone does a form wrong, and do recognize, we take that into account when we look at the fines. There's some that are worse. We increase or request an increase in those that are worse. Some are minor, and we try and take that into account instead of just doing the same number for each case. If there are 2 mistakes, depending on the seriousness of the mistakes, we try and take that into account. So I just wanted to let the commission know that we do recognize that, and we try and act in that manner.
Commissioner Miller?
Commissioner.
I mean,
Don't insult her
Mrs.
that
Miller.
way.
She's much higher than us.
I would just like to say that when we take these cases to DOA, the last few cases that we've tried, there has not been a recommended finding. So we try to get something up front, because if we go to DOA, we can't be assured that even if the facts are there, we will win.
Thank you, that's helpful. Commissioner Gates, you look like you want to say something.
I do, but I won't.
Okay, we have a motion before us. All in favor, say aye.
Aye.
All opposed, like sign. Show it adopted. The next case is number 2211, Tracy Davis. Ms. Hadley, you are the advocate. Is Ms. Taryn, you?
Mark Aaron on behalf of Representative Davis.
Thank you, sir. Ms. Hadley, you're recognized.
Respondent serves as a sitting state representative. The commission found probable cause to believe she violated Article 2, Section 8, Florida Constitution, and Section 112.3144 Florida statutes by filing an inaccurate 2019 CE Form 6. The parties have come to an agreement where respondent admits that she violated the Code of Ethics and has filed an amended form. Since respondent is a sitting member of the House of Representatives, the commission would refer this matter to the Speaker of the House for action consistent with Section 112.324, subsection 4, Florida statutes. In this case, as noted earlier, the commission does not provide a recommended penalty at this time. We respectfully ask for the commission's approval of the joint stipulation.
Are there questions of Ms. Hadley? None appearing. Mr. Herron, you're recognized.
Chairman, members of the commission, again, this is a case where we report to the House of Representatives for their review of it. We ask you to accept the joint stipulation so we can move on.
Thank you, sir. Anybody have any questions of Mr. Herron? Do I hear a motion?
I'll move adoption of the joint stipulation.
Second.
Commissioner Wallman moves, Commissioner Gilzine seconds. Any discussion? All in favor, say aye.
Aye.
All opposed, like sign. Show it adopted. The next case is consideration of final action on a post probable cause stipulation. Alexis P. Rodriguez. Ms. Miller, you are the, not the commissioner, you're the advocate. Is there anyone here representing the respondent?
No, sir.
Ms. Miller, you're recognized.
Thank you. Elizabeth Miller, advocate for the commission. Commissioners, you will remember this case. You rejected the original stipulation of $6,500 and suggested a higher civil penalty, and that is what you have before you. The maximum penalty of $10,000 per allegation for a total of $20,000 is what this respondent has agreed to, along with a public censure and reprimand. And I ask that you adopt this stipulation.
Are there questions of Ms. Miller? Not appearing, and the respondent not being present or represented, do I hear a motion?
I will move adoption of the joint stipulation.
Commissioner Waldman moves, Commissioner Gilzine seconds. Is there discussion on the motion? Commissioner Waldman.
Thank you, Mr. Chair. I just want to say I commend Ms. Miller on this because I do remember the discussion we had, and to get to the joint stipulation of what is the maximum fine, if I understand correctly anyway, that's pretty good. The question I have is, what happens if he doesn't pay?
Through the chair, we are taxed with collecting the money. We will, if he doesn't start paying, we will sue and get a judgment and then try to get the money somehow. But we do collect the fines.
Mr. Chair, just to follow up. So, I mean, this is exactly the type of a case, as I look at it, where there are not innocent disclosures, I guess, or mistakes, I should say, on it. And that's the distinction between the last case that we have or the others that we had. It's one thing to make a mistake that's an innocent mistake. It's another to actually totally misrepresent things. And I think that that's where the distinction in the amount of the fine should be. And this one, of course, I think happens to be egregious what took place here. But I fully support my motion.
Okay, all in favor, say aye. Aye. Opposed, like sign. All right, that takes care of the stipulations. We now move to item 6, the consideration of advisory opinions. The first one is file 2785. It's not only the first one, but is the only one. And as you all know, any public officer, candidate for public office or public employee in Florida who is in doubt about the applicability of disclosure laws or standards of conduct to him or herself, or anyone who has the power to hire or terminate another public employee, may seek an advisory opinion from the commission about that situation. And advisory opinions, I would remind you, are based solely on the facts provided by the requestor and are legally binding on the conduct as issued. We do not do the kind of extensive investigation that we do in complaints because people are asking for our opinion, and they give us the facts as they see them, and we give an opinion based on the facts as presented. Is the requestor here? Okay, no. Steve, you're recognized to present the opinion. I'm sorry, Commissioner Carbajal.
Mr. Chair, for disclosure, the organization I work with, Florida Tax Watch, has some ongoing relationships with the school board of Broward County. None in the nature that are pecuniary. We would not inure any better. I would not change in my position. So this is only a disclosure. I will plan to participate, and it will not influence my decision.
Okay. Steve, you're recognized.
Thank you, Mr. Chair. Commissioners, this opinion was requested by Dr. Rosalind Osgood. She's the chair of the Broward County School Board. In her opinion request, she explains in detail that the school board voted to institute a policy. In response to the policy, the Florida Department of Education issued an order finding the policy to be out of compliance with the law. The Florida Department of Education ordered the school district to withhold state funds equal to half the amount of the salary of the school board members, and said the school district's budgetary shortfall must be applied only to the salaries of the school board members. After that order was issued, the United States Department of Education made funds available to the school district and every other similarly situated school district in the country to replenish the budgetary shortfall so the school board members could receive their full salaries from the agency. Contemporaneously, members of the public contacted the school district about starting fundraising efforts on GoFundMe.com and donating the proceeds to the school district so that the school district could pay the full salaries of the school board members. In her opinion request, the requester asked 3 questions, but the third question was eventually withdrawn. The first question was about the funds from the United States Department of Education, and the second question was about the GoFundMe funds. In both instances, she asked whether the Code of Ethics would prevent her from accepting her lawful salary from her agency if her agency accepted either the funds from the United States Department of Education or the GoFundMe funds. The opinion analyzes both questions under the gifts law, which is section 112.3148 Florida statutes, the bribery prohibition, which is section 112.313 subsection 2, and the unauthorized compensation prohibition, which is section 112.313 subsection 4. The draft finds that the gifts law is not applicable in either the United States Department of Education question or the GoFundMe question. The only thing the school board members are receiving in the facts presented is their full salary, which is coming to them directly from their agency. The Commission on Ethics has a rule. It's Rule 34-13.210, subsection 1B. The rule says salary, benefits, services, fees, and other expenses received by a public officer or employee from his or her agency do not constitute gifts. The rule does not make any distinction based on where the agency gets its funding from. Therefore, by definition, the agency salary received by the school board members is not a gift, and they may accept their salary under the gifts law, according to the draft. The opinion also states that salary payments received directly from one's agency in the amount prescribed by law are not bribes and are not unauthorized compensation. The payment of their salary by their agency is not a quid pro quo or an attempt to influence the school board members, as the Code of Ethics would prohibit. The draft notes this is merely lawful compensation for carrying out their official duties. The outcome makes sense because it comports with our shared experiences as public servants. To be clear, this draft opinion does not speak to the efficacy of the school board's policy or the Florida Department of Education's order. For purposes of this draft, it doesn't matter what the details of the policy or the order even were. They were just circumstances that led to a budgetary shortfall. And that budgetary shortfall is now being replenished by either the United States Department of Education or the GoFundMe donations. The draft does not speak to whether masks are effective in preventing the spread of COVID-19. To the contrary, the draft does not even include the word mask, and it only mentions face coverings once as a quote of the name of the policy in a footnote. The draft was very careful to keep this agency's consideration of the opinion request above the political discourse concerning the issues in the background of the opinion request. The draft instead is careful to focus only entirely on the ethical implications of the school district receiving funds from outside sources and applying those to fill the budgetary shortfalls in salary expenditures. With that being said, I'm available to answer any questions you may have about the opinion request.
Are there any questions from members of the commission? Commissioner Carvajal.
And I understand the context that we're asking all these questions, and I appreciate how careful we might be on all these questions, but a few things just to help me understand, and through the chair I'll ask a few if you don't mind. The first thing you're saying is that in either situation it's a replacement of salary. And I understand that statement, but wouldn't each scenario require them to vote on that issue, and would there be a voting conflict in any way, given that in the initial salary approval, it was done probably through some sort of appropriating item, and each item after that comes into play?
We have a bunch of opinions that concern voting on matters affecting one's salary. And in each instance, we have said that voting, there's a statutory prohibition. The site escapes me at the moment, but it does say that voting on one's salary is not going to be a voting conflict.
It's an exception contained in 112.313, subsection 5.
Okay, thank you. A slightly different question for Matt, before I bring some other items in play. We have had conversations that the donors, in separate cases, not in this particular case, that the individuals who are contributing to the GoFundMe fund actually make a difference to whether something can be distributed. I will acknowledge that it is a completely different situation. I'm thinking of something, for example, to cover medical expenses of somebody that works for the legislature, and it's not going through the appropriating entity for, in this case, it would have been the legislature. But what we had said was that lobbyists couldn't be contributing to the GoFundMe fund because it would inure to that individual. Since it is clear that the GoFundMe dollars would be going to the salary, would it make any difference who can and can't contribute into that GoFundMe fund?
No, it would not make a difference. The draft states, for purposes of answering the question, that the source of the funding does not matter. And the reason for that is in the situation that you were discussing, I believe the money was going straight from the GoFundMe donor to the individual. In this instance, this is going to the agency. The agency is then deducting taxes and all sorts of other benefits and then passing along salary dollars. We have a rule that says salary is not going to be considered a gift, so the prohibitions in the gifts law that would make lobbyists a prohibited donor wouldn't apply. This is because it's not a gift in the first place.
Through the chair, and just to clarify where I'm thinking that the challenge becomes in what you had just argued, the GoFundMe is not going directly into the salaries. The GoFundMe is going into the agency.
Correct.
Are there any rules or prohibitions from a GoFundMe fund, for example, from a large contractor or somebody that benefits, to donate to the school board? Because while we are assuming that the ultimate destination for those dollars is salary, it may or may not come to pass.
Sure. So the agencies themselves, for the most part, do not have obligations under the Code of Ethics. The Code of Ethics obligates individual public officers and public employees. In the instance where there was some sort of nefarious undertaking with donating this money, the controlling statute that would prevent the corruption here would be the misuse statute. If somebody was seeking to accept funds to benefit another individual, to later take a public action to benefit an individual with a corrupt intent, we would find a misuse under such a situation. So, and that's still in play here. The opinion does not discuss the misuse statute because it wasn't asked about, but the misuse, this doesn't at all mitigate any liability that somebody would have for committing a misuse of their office to benefit another individual.
I think it's more appropriate under discussion when I bring it up, but I'll ask it in the form of a question so you can help me frame my conversation. The donors to the GoFundMe fund are intending it to go to salaries, but there's no guarantees that it will. It is being contributed to in this case, the school board or the district. And what I'm hearing you say is it doesn't matter because that would be like any other contribution.
It doesn't matter under the gifts law. If you are asking about bribes and unauthorized compensation, somebody is supplying this money, and won't I be ever grateful because they replenished money that will eventually lead to my salary? If that's what you're asking. The money it's their lawful compensation, right? So on one hand, they've earned this money because they've agreed to do their public work, their public service. In the case of public officers, but also in the case of public employees who are equally liable under this law, they are putting in labor and sweat to perform the public business. So it's lawful compensation on one hand. It can't also be unauthorized compensation, right? So it's either lawful compensation or it's unlawful compensation. If we take the opinion that it's unlawful compensation and that they shouldn't be accepting their own salary, in the case of public employees, we're going to have a situation where they're going to have complex labor, wages, and hours issues where they can't accept money for wages that they've earned. This will be a nightmare for local governments across the state. And it can't be the case that the Code of Ethics prevents somebody from accepting their own salary. That would be the position that we would argue here. Instead, to prevent the type of corruption that you're talking about, if we actually are worried that they're going to do something because their salary was replenished, the misuse statute would step in and would say you cannot take a corrupt act to benefit somebody else, and if you do, you will be liable under that and possibly also the constitutional prohibition for disproportionate benefit.
Thank you, Mr. Chair.
Mr. Chairman. Commissioner Gilzine.
To follow up on that thought that they actually earned it, the issue here is that the state is withholding the dollars due to the fact that they violated the law. They're not saying that they're not going to get it. So if the school district ultimately comes in compliance with the law, wouldn't that entity receive the funding? So then if that's the case, no, let me ask the first question and I'll ask my second.
So to be clear on what's being withheld here, right, and who it's being withheld from, the order states that the school district must do the withholding. from, I'm sorry, the school district must withhold state funds from itself. This is not discipline as far as I read the order. It's not discipline on the individuals where they're being fined in their personal capacities to receive, prevent them from receiving salary, right? This isn't like a suspension for a public employee where they're unpaid suspension where they're losing salary dollars. This is the agency has been ordered to withhold these funds and can only apply the budgetary shortfall to the salary. So in that sense, it's not a statement that they are not still owed as their salary is described in law, in statute, and this isn't a statement that they don't get the money or that they haven't earned the money through their public service. This is a statement of how the budget for the entity, the agency, shall be applied and how the money shall be routed, as far as I read the order.
Commissioner Gates.
Thank you, Mr. Chairman. Unfortunately, the Ethics Commission does not operate in a hermetically sealed container. And the fact is that through this request for an opinion, we are being entangled, or someone is attempting to entangle us in a wider political and legal debate. And I think counsel would recognize that fact. My question, I have a series of questions, but before I get into them, I have I guess a broader question. You state that the school board members are entitled to their lawful compensation, their lawful salaries, and that this grant or gift, whatever one might call it, from the federal government to replace the money that the Department of Education, the State Board of Education is saying can't be paid for these salaries is not a gift because it's simply replacing lawful compensation. But isn't it the case that the question as to whether or not the compensation is lawful and it is lawful to pay the salaries is an issue that's being litigated in this building? And isn't it the case that that right now, as I understand it, please correct me if I'm wrong, the appellate court has issued a stay that permits the State Board of Education to enforce, under its powers, the decision that it's made to have this compensation withheld. So you now have a debate going on, political debate and a legal debate, as to whether or not it is lawful for this compensation to be paid. And are we not entangling ourselves in this matter by virtue of a request that we throw a blanket of approval over these federal funds that are being used in what the state says is in an unlawful way?
So the answer to the first part of your question, when I refer to the salary as being lawful, and potentially I'm being inartful here, but the salary as provided by law is what I'm referring to here.
Lawfully paid, then, shall we say?
Right, properly paid through as according to statute, and properly calculated, properly administered, or in the normal course as provided by the statute. This order being an intervening act, of course. With regard to your second question about the wisdom of stepping into this now, this commission, where there's an active court case going on and what the state of the stay is, the question has been posed to us, and we step in to answer because it's my position in this draft that the context for the situation doesn't truly matter. This is a draft that's kind of agnostic as to the context. It's salary dollars are not going to be a gift regardless of where they come from and why there's a budgetary shortfall. It would be my best legal advice that salary dollars are not going to be a bribe or unauthorized compensation. for the reasons stated in the brief. And that would be, again, regardless of the context. If, and that's what the draft states, and that's why we felt like it was ripe to present to you.
Mr. Chairman.
You're recognized.
Thank you, Mr. Chairman. But again, we know that there are parties who have an interest in the outcome. We know that the state has an interest because of its policy decision about the masking. It has an interest in this outcome. We know that the federal government, the Biden administration, has an interest in this matter. And all one has to do is simply breathe the air and feel the sunshine and the rain to understand that the Biden administration has made it very clear that the reason they're doing this is because they want to influence the outcome and support a decision with respect to the masking. So how can we say that there are no parties attempting to use funds to influence or to congratulate or to support or to oppose a certain vote on a certain policy issue with respect to this matter?
Well, we know that because the policy decision was made first. And so the money that came in second after the policy. There's nothing left to influence because the policy decision had already been made.
Oh, really? You don't believe that there's an open political debate now as to what will happen with respect to the Broward County School Board's decision and the Alachua County School Board's decision and perhaps others?
Oh, I mean, I think you're fully aware that I'm very cognizant of the political discourse around it, and I believe that that's true. The posture that I'm here is to give my best legal advice on it, but the answer, I think, is one of policy for this commission, and this is something that's, whether or not to wade in on that matter will ultimately be up to you. As far as whether or not these salary dollars are meant to influence, I mean, the draft would stand for the proposition that they're not. If you feel differently, this draft is not going to be appropriate for adoption.
Mr. Chairman, I'd like to defer to my colleagues for their comments and questions, but I will ask to be recognized later if it's appropriate.
Okay, Commissioner Carvajal.
Thank you. I'll clarify that I have less concern with the first recommendation, the answer to the first recommendation. I have lots more concerns with the answer to the second recommendation. And I'm going to try and clarify them so you can help me understand. Your assumption, which undergirds your opinion, is that the dollars are being donated for salaries. But you can't make that assumption because it must be appropriated ultimately from the school board. The dollars are going to the school board. So I think my concern with the recommendation you're providing is that you've made a leap that is not possible in the recommendation. And if you'll allow me so that you can form a response to the second half. Here's my concern, is the moral hazard that we are truly raising in this situation, where I always go back to what if it was a completely different situation? And the school board was sending signals to the public that if you raised a GoFundMe for $5 million, I would do Y. And it doesn't matter whether it's masks or at football stadium or reapportionment, voting somebody out, superintendent, whatever it may be. There is a bad signaling effort here that a public campaign would influence us supporting or opposing anything. So it's that leap that you are making that the GoFundMe is actually going to salaries that I am uncomfortable with, because it is presumed in the request, but the dollars are only actually going to the school board. So I would feel much more comfortable if this was a donation. And then whatever comes of how the school board represent. And the reason I don't hold that same opinion for the first is because the U.S. Department of Education is an appropriator to school boards, and there are different items in play.
So my priors on this are that the order from the Florida Department of Education states that there's going to be this budgetary shortfall as a result of the order, that the district will be ordered to withhold the funds. The second part of the order states that the amount withheld cannot be offset in any other area of the budget other than salary expenditures for these board members. So the gap in the budgetary expenditures can only be applied to the board members. So if there's new money coming in, the request is asking, if we apply this to salaries and these board members are receiving the salaries, do we have an ethics problem? So the question that you're being asked presupposes that the money is being filled, being applied in that way. On the second question, which is, help me out, please.
The moral hazard of signaling that if the public raises dollars for these things will influence our vote, I think is where I'm really concerned at what precedent we are setting in that case, in that setting.
This is the situation being presented here is pretty strange because there is a shortfall in the salary dollars. So you always have, when in any gifts or unauthorized compensation situation, you're always looking at what are these people getting. In this instance, this person is getting from their own agency a paycheck equal to the amount that they otherwise would have expected, and that is provided for in statute. In any other situation where that budget shortfall does not exist and donations are coming in, if the public officers are getting money in addition to their salary, up and over and above what's provided for in law, this draft does not speak to that at all. This is not, and several times it talks about salaries as provided for by law and in the draft. Nobody would be able to look at this opinion and seek cover to put out 20 GoFundMes and walk around with duffel bags full of cash.
Further questions? Commissioner Meggs.
Let me be a simple-minded person here a second. We've had a request for an opinion about whether receiving their salary is a gift. You've answered that in the negative. You've had a question about whether receiving a salary is a bribe. You've answered that question. And there apparently is an order, I don't know the validity, the strength, the power of that order from the Department of Education and maybe our governor, that the salaries will be withheld from school board members if they violate whatever the deal was. So if you answered the questions asked, it's not a gift, it's not a bribe, may be unlawful, but that's not we're not here to determine what's lawful or unlawful. So I guess my question is, can we just say we don't want to be involved and we're not going to give you an ethics opinion?
Oh, believe me, I tried that, but this was assigned to me.
Well, I mean, I guess I'd ask that because I think you've answered the question correctly. It's not a gift, it's not a bribe. Is it unlawful?
When I say
maybe, and they're litigating that somewhere else, so that's someone else's fight, not our fight. So if we can answer the question, we've answered it.
Just to be clear about the vocabulary I'm using here, when I'm talking about unauthorized compensation, Section 112.313, subsection 4 is titled unauthorized compensation. That's what we're talking about when we're talking about unauthorized compensation. We're talking about money given, a thing of value being given to another for the purpose of influencing or with the given to them to influence their official judgment or decision making. That's what I'm talking about when I'm talking about unauthorized compensation. Whether the school board member, whether or not the school district can apply this as a procedural step to apply it to salary, we are not stepping in that. That's not what we're stepping in. All we're saying is whether or not, if it is procedurally okay, and we don't know if it is or it isn't, or whether or not it violates some sort of other payroll statute or something like that. But if they do receive a paycheck like this, whether or not it's going to put them in an ethical quandary in the Code of Ethics, and the draft says no.
Let me recognize Ms. Stillman.
Commissioner Meggs had asked the question about what if you don't want to issue an opinion today, and that is the purview of this commission in terms of how you feel about this draft, adopt it, reject it. You do not have to issue an opinion today if that is the will of the commission. This draft is put before you for your consideration, and it is up to you how you act today in terms of this opinion.
Mr. Chairman.
Commissioner Gates.
Obviously, there are parties materially affected and parties in interest. Has the governor been given the deference to be informed of this matter and to know or be requested to have his Department of Education or the Board of Education provide you with their analysis of the facts and the law as to this matter?
No, there's a couple of reasons for that. First and foremost, your legal staff here is obligated to give you its best legal advice. And, so that's what I'm here to do today, free of any influence from the outside. Of course, as you know, we're not subordinate to any of these other, the three branches of government. So there isn't anything in our statute that would obligate us to present that forward. So this draft is being presented to you straight from my desk.
Mr. Chairman, I grant you that I wasn't asking you whether or not you requested the governor's permission or asked to be influenced, but rather the governor of the state of Florida is a party materially affected because the decision that we make will be used as a cloak of approval or disapproval. And it seems to me that at the very least, we ought to ask for a memorandum or a letter or some indication as to how the state views this matter. I believe Commissioner Carvajal has opened a line of very interesting questioning as to the whole GoFundMe page. I think it spills over back into the whole issue of the federal government. I mean, obviously, if the primary contributor to the GoFundMe page was the committee to support or oppose masks, you'd be hard-pressed to say that somebody accepting money as a consequence of that, even if it was in what you would construe as their salary, that they wouldn't be influenced, or that they couldn't be influenced, or that it wasn't done with an attempt or an intent to influence. I think this matter entangles us in all sorts of things. As I indicated, the whole issue of whether or not the withholding of the salaries is lawful is being litigated in this building. It's my view, Mr. Chair, and I would offer this as a motion that the Commission on Ethics tables this matter pending the call of the chair to re-agenda it if and as there is an appropriate time to do so.
Okay, is there a second to Commissioner Gates' motion?
I'll second.
Okay, it's been seconded by 2 or 3 people. I'll recognize Commissioner Gilzine. Ms. Stillman, do you want to add anything on that before we vote?
Thank you, Mr. Chair. Just in terms of the posture of the opinion request and why additional information was not sought from other agencies, when something comes before us as an opinion request, the draft that comes before you is based solely on the information provided by the requester and an answer to their question, as opposed to something that might be investigated more, or where sides are contacted to get their legal input on their position on the matter. So we squarely limited it to the jurisdiction of the commission and the information provided in the request. Thank you.
Commissioner Carvajal?
I'm going to continue on the debate, and I intend to support the motion, but I actually believe that we're getting good counsel from our lawyer in a very difficult situation. I can only imagine what you must have done to make somebody mad to get this case assigned to you at this moment. But let me go back to the actual question that was submitted and actually the question that you answered, because I actually do not want to get engaged in the answer of whether this is about masks or anything else. I want to get to the question that was asked, and that is, if a third party raises dollars for the purpose of giving it to the school board with intent known by particularly the school board, but by others, that it is directed towards salaries, that seems to me to be a moral hazard. And change masks. This is not about masks to me. It's a football stadium. It's a school in my neighborhood, and very affluent individuals want to reward, let's just say, with increased salaries down the road, by raising additional dollars to donate to the school. It just seems that there's a quid pro quo there. There is this public action outside that's saying, I'm going to give the school board all this money if the school board acts in this fashion. And the question that was asked was not about masks, so it's not just this instant situation. In both the letter submitted by Broward, as well as the way you framed it in the opinion, it is third party donating to the school district applying those to salaries. That question bothers me. I will support the motion to table, but I want you to understand what my real question is here. I'm not trying to engage you or us in the broad question of the day. There are legal matters that are being resolved, and that's why I will support the motion to table. But as you go back and consider this, the bigger question to me is, can a third party be sending signals that the school board should vote this way for salaries? That is the question that was submitted. That is the question that you reframed. That one bothers me, and I will vote no every single time. It has nothing to do with how I feel about instant situations.
Is there further discussion? Commissioner Gozine?
So unlike my colleague who wasn't really focused on opinion one, I am, and the reason why is that after looking at section 1118 subsection B1 of the U.S. DOE code, where it talks about supplement and not supplant. And it says here that federal funds, as it relates to supplement, must supplement, increase, add to, enhance the program or service offered within the state or local funds, whereas supplanting, federal funds are not prohibited to be used as a supplant, take in place or replace the state or local funds used to offer those programs or services. So what I see here is definitely an opportunity to supplant versus supplement. So I'm supporting the motion, but I think it's super important to be on record that we shouldn't give anyone an opportunity to violate federal or state law as it relates to that. You're good.
Thank you, sir. Is there further discussion? Commissioner?
One final comment, and that is, Council, I want you to know that I'm very respectful of the position that you find yourself in. I believe that the approach that you've taken, while I might disagree with some of your conclusions, I'm not a lawyer, you are, and you're a good one. So my motion is not meant as a motion that suggests a lack of confidence in your recommendation or in the good work that you've done, but it is only what it says that it is, and that is a motion to disentangle us from this matter, which is being resolved legally and politically elsewhere.
I appreciate the soft touch, but, I'm not offended if you do or don't.
I know you're a big guy, I understand.
Let me, I'm going to call for a vote here in a second, but I want to call Ms. Stillman again to make a comment about what our rules provide so that we're very clear in what we are doing. Again, and Steve, I think you've done an excellent job dealing with a very difficult situation.
Thank you, Mr. Chairman.
But if somebody requests a legal opinion, they bring in certain facts. And certainly, we can do some research to help understand those facts, but it's not up to us to determine whether what they say is right or wrong. They're saying, in this situation, what is your opinion? But we have to be very careful doing that, because once we issue an opinion, it becomes binding, and it can be used in a court of law, it can be used before the legislature, it can be used in a number of situations, perhaps even a criminal case. So we have to be extremely careful about what we do. And I think it's the consensus. We haven't taken a vote yet, but I don't think there's a consensus here to adopt this opinion as it is presented. But I want Ms. Stillman to elaborate on what our rules provide as to the action that I think we're about to take.
Thank you, Chair. Under 112.322, just to clarify what we can do here in terms of TPing, we can adopt the opinion, you can reject the opinion. If you choose to TP it today, we would need to bring it back to you for consideration at some point, because the requirements of law indicate that it can be adopted or rejected. And Caroline can speak to the rule with regard to opinions as well.
Indeed. Section 112.322, subsection 3A, sets forth the standing requirement, and this district school board member who requested this analysis satisfies that standing requirement, and in such instances, it provides, quote, an advisory opinion shall be rendered by the commission. Our rules then further clarify what our universe of possibilities are in this posture, and it provides that advisory opinions may be adopted in full, amended as you see fit as a collegial body, modified, or rejected. And so I just wanted to clarify the procedural posture for the purposes of proceeding in this matter.
Thank you. That being said, I want to call on
Mr.
Commissioner
Chair,
Gates.
I'm sorry.
to-
If you were calling for a vote, I wanted to speak.
Okay, let me just ask him to clarify his motion based on these rules, because are you suggesting that we outright reject the opinion, or that we temporarily pass it and bring it back? Now, my understanding of our rules, unlike the legislature where you and I served, if you temporarily pass something, it automatically comes back on the agenda at the next scheduled committee meeting. But I think in this situation, it would come back on the agenda when the chair agrees to put it on the agenda. So it would not necessarily mean that it would come back at the December meeting. So are you voting temporarily, are you moving to temporarily pass or to reject?
Thank you, Mr. Chair. It is the intent of the motion that the matter be laid on the table until such time as the chair of this commission re-agendas it. If that is, and I would ask a parliamentary question of the executive director, is that an appropriate motion? If it is not an appropriate motion, and if the only choice is fish or fowl, I'm prepared to choose off the menu, but I'm trying not to do that at this point, out of deference to a lot of the unanswered questions that still remain about this matter.
Through the chair, I would like to recognize the general counsel to speak of the legality of postponing.
In our rules, it makes it clear that the person requesting, who has standing to request the opinion, provides the universe of facts, We can ask clarification of those facts, and Steve Zlokowski has done so in this instance, and that they are the only party. And so the instant measure can be subject to the universe of possibilities, but we cannot unilaterally change the facts or add additional parties to the analysis. But we can, and you as a collegial body are afforded great latitude to modify it, to accept it, reject it, or amend it.
Madam Chair, Mr. Chair, I apologize. I didn't quite understand the answer. My question is simply, is it in order to lay this matter on the table, subject to the agending of this matter by the chair? Yes or no?
The statute contemplates that we shall render an opinion eventually.
Then
But
Mr. Chair, point of order, actually, and since, if I'm not mistaken, and here's the clarifying question that could help in this. My understanding is we work under Robert's rules, not Mason's, which is the legislative process. Is that a correct answer?
I would defer to the executive director, but I believe we do not.
We do not have a rule regarding Robert's Rules of Order or Mason's Rules of Order. In terms of agending items for a commission meeting, it is generally done by virtue of the work that comes before the commission as opposed to a chair discretion.
Mr. Chair, in that case, I appreciate the clarification, and as a junior member of the commission, I defer to senior members who have more experience in this matter and would have known what I did not know. And so that left with only those options to accept, reject, or modify, and in view of the unanswered questions at this table that have been expressed and perhaps others that haven't been expressed, I move that the opinion be rejected at present, leaving, and that my motion would leave the possibility the matter could be brought by staff at some future time, I think, but I move to reject the opinion as it's presented.
Okay, that substitute motion having been made, is there a second to the substitute motion?
Yeah,
All right. It has been seconded. Now, Commissioner Ankers asked to be recognized, and then Commissioner Carvajal.
Thank you. And Mr. Chair, I realize you were trying to count votes and heard 4 seconds to the previous motion. So if by consensus you mean majority, I agree you have a majority, but I don't think you have consensus in terms of unanimity on either the previous motion or this motion. And for me, that is because for many issues that come before this commission, I would love to defer. I would love to defer to third parties, such as other elected officials who might have opinions on this. But that is simply not what we have been appointed to do. We have been appointed to make difficult decisions. This is certainly not the first. It may be controversial, although I would not have thought that when I woke up this morning. I love the law because it continues to astonish me with the diversity of opinions that come to what I genuinely viewed as a very straightforward question of law with a messy and difficult and complicated set of facts. Only politically are they messy facts. They really are not messy in terms of the sequence of events that have occurred and the application of the law. We frequently are tasked with, whether they're in advisory opinions or in opinions that we make decisions based on complaints, we are always giving our cloak of approval. We are always materially affecting parties. We are always having to give deference to some position that is persuasive to us. There are many times collateral proceedings taking place in this building or in another circuit or even at the Supreme Court. There are frequently criminal proceedings that are running another track, and we are still called upon to make a decision based on the law and the facts. I think asking for third-party opinions, whether we do it, even if we make a decision today and then later ask for that, is a dangerous path to take, because I think that there will be no end to the breadth and depth of the opinions that we get or that we seek. The conclusion that is reached in this advisory opinion simply states a very clear matter of fact that salaries are not a gift. And I am concerned that the moral hazard here really is not taking the moral courage to render an advisory opinion that says what the law reflects.
Thank you. Commissioner Gates, Commissioner, okay, who's next? Yeah.
I'll go with whoever's
Commissioner
ready. I appreciate Commissioner Anker's response, and we have not shied away from difficult situations, and I'm not wise enough to do that. I think in this particular case, the answer that seems to be thrust upon us is that we must give an opinion, and that is, I'm not denying that that is true, but it does not say that it has to be given at every meeting. We have in past situations asked our council to look at particular questions, and it keeps coming back. So I reject the latter motion because I'm not under the same haste. I think the original motion, which I supported, was table until we had legal opinions to provide further comment, which is the one I'd like to support. But I don't feel the haste to answer in a particular situation right now. There are questions that should be answered. The questions that were submitted have to do with third parties providing gifts. I'd like to know more about that in different situations. But obviously, I will go along with where the commission stands. I'm not afraid to take a position in this particular case, and I also do believe lawful salaries should be paid, but there are recourses for those processes separately. But that's not the question that is before us.
Mr. Chair,
Commissioner Gates.
Commissioner Akers is the smartest person I know. I said that when I appointed her to this commission several years ago, and it still is the case, and I defer to her brilliant analysis. And by the same token, I only made the motion that is now on the table because we were being advised by staff that we could not lay a matter over for further deliberation. Well, I'm going to try that motion again. I'm going to withdraw my motion to reject. There are a series, we could go on for a long time today, just, I think, with the questions that have been raised and others that I've noted down. I would like, with the permission of my seconder, to revert to the prior motion, and I'll be happy to style that motion in different ways if the chair wants it. Let me try that motion again, and that as I move that this matter be laid on the table until it is re-agended after further legal analysis.
Okay, and I've forgotten who seconded that motion.
My seconder was here.
Travis, Commissioner Cummings, that's agreeable to you to withdraw the first motion. Okay, now we have the second motion before us. Is there a second?
I think he's the second. Yeah.
Okay. So,
Willing to the end.
I need all the help I can get today.
The jacket he's wearing is very intimidating.
all right,
I have one thing.
Commissioner Gilzine.
So with that said, as you're doing your legal analysis, please come back regarding the supplement versus the supplant laws that's in place at the federal and state level as you come back with your opinion here, please.
Yes, sir.
Thank you.
So noted. Commissioner Meggs.
I just think we've made something that's relatively simple very complicated. The question asked of us is, if I receive my salary from the school board, is that a gift? The answer to that is no. If I receive my salary from the school board, from whatever source, is that a bribe? The answer to that is no. And I believe that's basically what your draft opinion says. So to bring it, to make it so complicated, if you tell them that, and then the Department of Education says, well, if you take money because we've entered an order saying you can't take a salary, we're going to do something to you, that's not our business. And that's somebody else's business. So if everybody will do what they're supposed to do, our system tends to work, in my opinion. So I will be opposed to tabling it. I think the question is a very simple issue. It's not a bribe, it's not a gift. It may be unlawful for you to get it, and if it is, something's going to happen to you, but that's not from the Ethics Commission. Now, I don't know if that makes sense to y'all, but it does to me. I think it's pretty smart, but that's my story, and I'm sticking to it.
Any further comments?
Yeah, Mr. Chair.
Commissioner Wallman.
Thank you, Mr. Chair. So when I was in the legislature, my role was to manage the debate on the floor of the House. And I used to tell all of my colleagues, if you're not going to add anything to the debate that has already been said, then don't say it. So I don't have anything to add other than what Commissioner Akers said. Commissioner Megg said very well. This is something we should deal with today. I'm opposed to tabling it, and I think it is a very straightforward situation.
Further comments?
To the question that, as posed by Commissioner Meggs, I think my challenge is I actually disagree that it is as simple as the second one, and I would oppose that because if there is an acceptance of gifts for salaries, regardless of why that happens, that to me presents a moral hazard. That is what I am opposed to. And if, as you framed the question was, can salary go to school board members if it was raised from a private third-party source? If it is that simple, then I stand no. I'm going to oppose that whenever it appears, because it doesn't matter in this situation or any other situation. A third party influencing the school board in such a way seems to be a problem for me. So my problem is, if we pass this, obviously, like every other vote that we take, I will support the position of the commission. We're all ride or die in this sense, Senator Gates, but I just oppose the notion. So I just wanted you to let you know where I would vote on it. And if it means that the entire opinion gets my no, that's fine.
Further questions? Commissioner Wallman.
Thank you, Mr. Chair. I guess a point of order, certainly you can look to amend his motion if you think that you want to modify the opinion. We can always modify the opinion if that's the case and take a vote on it. But I'm suggesting that we not punt and we not just say, okay, let's pass it down the road. Let's do something today, because I think there's consensus, maybe not, maybe the votes for question number one in the pot to answer that in the consistent with what Steve has said. So we can certainly bifurcate this at this point and modify if you want to do that, and then everybody can get, maybe we can take some action, everybody gets a little bit of what they want.
All right, that's a suggestion, but that's not in the motion. Motion is before us. Is there further question on the motion?
What is the motion?
To table.
I'm
To
sorry?
table it? Is the motion to table?
Yes.
Yes. All in favor, say aye.
Aye.
All opposed? No.
Nay.
Show it passing. So it is tabled. Thank you, Steve. You, as always.
Looked like a
Can we
tie to me.
have a roll call, please?
Sure. Tie vote.
I'd like to move for the adoption of the opinion of the council.
In bank.
Second.
Yes,
The entire, you're not, because you suggested before maybe bifurcating.
right. Right, I'm doing it for both issues at this point.
Okay. So Commissioner Wallman has moved to accept. Commissioner Meggs has second. Is there discussion? None appearing?
So, I have a question, and it's just more of, if this fails again in a tie vote, what would happen, Madam Executive Director?
To the chair. If this fails on a tie vote and the members cannot reach a agreement as to what should have, we would agenda it for the next commission meeting in December and bring it back to you for consideration, where we would hopefully have all 9 members present for consideration, and with whatever direction provided by the commission for that consideration.
Okay. All right, Commissioner Wallman's motion is before us, and that is that we accept the opinion as drafted. All in favor, say aye.
Aye.
Aye. All opposed?
Nay.
Nay.
Call the roll.
Yes.
No. No.
No.
Yes.
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 All right, it's a tie vote. You will see it again.
Mr. Chair, I believe we can still make another motion. I'd like to make another motion.
Okay, you're recognized.
My motion is that we accept the opinion as it relates to the first issue.
All right. Is there a second?
What is the first issue?
That was the, that the money coming from the US DOE as opposed to the GoFundMe. First question.
Do I hear a second? Caroline?
For clarity, in your motion, are you contemplating approving question 1 and rejecting and omitting question 2?
I don't know. That's a good question. I just wanted to bifurcate this, and so, because I think we can get a positive vote in, as it relates to question number 1. So at this point, I'd just like to limit it that we are answering question 1 in the negative.
So, Mr. Chair, and I don't know if this is the right posture or not, I really would like the legal analysis on the supplement versus supplant law as it relates to this. I think that's a very important key of information in order for us to vote and make a decision.
If I may, on the issue of interpreting the federal law and to the extent that some of this appears in the K through 20 education code, your legal staff is brilliant as we are. We do not have the expertise in the area of education to be able to opine as to, kind of like what happened with the last time that we had an opinion like this, to opine on other people's statutes and then tell them what is and isn't allowed. What the question is about the code of ethics. I could jam as much information about the code of ethics in here as you would like. I would be able to include a little bit of information about the supplant and supplement, but I don't know that we'd be able to put any holdings in there or that would say this shouldn't have come to the school district in the first place, or it's not proper that the federal government did or didn't do this. Those are procedural things about the payment that are outside of the code of ethics. If you're looking for some general information about supplement and supplant, I could include that in the draft probably as a footnote. But I don't know that we'd be able to make any holdings that would rely on that, just because it would require things that are probably well outside the scope of Chapter 112.
Commissioner Wallman?
After further thought, I think what I'd like to do on my motion is, to approve the opinion on question 1. As to question 2, I'd like to go back to staff to research the issue that Commissioner Carvajal has raised, on the third parties paying other than the United States Department of Education.
So just so I'm clear on what I'd be going back to do, is the USDOE money a gift? We would keep what the draft says. Is the USD money a bribe or unauthorized compensation? We would keep what the draft says. On the issue of, is the GoFundMe a gift? Because we're relying on the same rule as before, we're keeping that. And then the only question is it a bribe or a gift? Is that correct? Is that the motion?
Yes.
All right, is there a second to that motion?
I'll second somewhat reluctantly with a question, if I might.
Okay, show it, seconded by Commissioner Ankers. Commissioner Ankers, you're recognized.
May I ask legal counsel the question of, do you believe, put you in a tough spot, that there is any additional legal research that you have not already had the opportunity to complete on this issue that is being considered the second issue as postponing?
If I had had the foresight of what the conversation was, where the conversation was going to go today, I could have done a little bit more to represent both perspectives and then come to a conclusion that shows that everybody's been heard, that both sides have been heard, and then land on one side or the other. That's artisan. That's the artisan part of this. As far as the science goes, is there more research I could have done? Maybe. You know, I don't ever want to say no. Maybe.
Further questions or discussion? None appearing, I'm going to call for the...
Mr. Chairman?
Yeah, I'm sorry.
I guess this is a parliamentary inquiry. In the first motion that I made, which seemed to have support, what was in effect indicated by staff to be inartfully designed or out of order, I was calling for further analysis to be done before the matter was brought back before us because of the questions that have been raised here. But now we have a motion that calls for approval of part of the opinion and asking for, in effect, the same kind of analysis that I asked for as to some of the unresolved questions in matter two, and apparently it is in order. How is that the case?
Through the chair.
Because I don't have Carvajal's time.
It was the tie. Through the chair. With this situation, we're looking at bringing it back at the very next meeting. The situation with a TP that would take it to whenever at the chair's discretion, the chair might bring it back. That was the posture with regard to our rules in the law that we needed to tighten up a bit. If the commission's decision is they want additional research, you want it brought back at the December meeting, that's certainly what your staff will endeavor to do. We just couldn't do it without having an endpoint.
Well, that being the case, Mr. Chair, are you then now taking questions and debate on the motion before us?
Yes, I'm ready to call the question after people have had their opportunity to either insert into the discussion their opinions or ask questions.
Well, almost everything has been said, but not by everybody. As I understand it, the motion on the floor, and correct me, Commissioner Waldman, the motion on the floor is to approve the first part of the opinion and to defer on the second part of the opinion until further legal analysis has been done. Is that a fair statement of the motion?
Yes. But only to defer until the next meeting.
Until the next meeting.
Which this is similar to what we did, I think, with the University of West Florida or
Right.
something. We had that issue with the grants.
Yes. Thank you, and I appreciate that clarification. So as to the first matter, I just find it awfully hard for us to believe that we don't understand that we have all sorts of parties trying to influence the Broward County School Board. We have the state trying to influence them by saying, if you do this, we'll withhold your salaries or cause your salaries to be withheld. On the other hand, we have the federal government, the Biden administration, saying, if you persist in taking the position that you've taken now, which is in conformance with our position, we'll make sure that we get some money to you another way to pay your salaries. In both cases, you have parties attempting to influence, and they're using the payment of salary dollars to influence the actions of the Broward County School Board. And it seems to me that that violates the Code of Ethics, because it is attempting to use the payment of money, certainly the payment of money now to pay a salary that otherwise wouldn't be paid, in order to cause a school board or to influence a school board to persist in or continue to take a position that one part of the government, the federal government, the Biden administration, wants to be taken. And regardless of how you feel about the matter, you've got to go back to Commissioner Carvajal's original set of questions, and that is, imagine this were somebody else, and imagine it wasn't about masks. Imagine it was a different administration, and imagine it was a different issue. Are we really saying that we will allow, imagine, for example, if you had a group of municipalities or local governments in Broward County or any county saying, we'll throw together a fund to make sure you get your salaries paid if you promise never to approve more charter schools, or if you promise to always approve a charter school here or there, or do something else. The very fact that it's government money being used to attempt to influence the Broward County School Board one way or the other, it's still money, and it's still being attempted, using that money to attempt to influence. And so therefore, I find it to be very difficult to approve this opinion, because I think it leaves now open a moral hazard, and we may see this coming back in some other school board or some other governmental entity that does something that the governor decides is unlawful, and so they withhold their salaries. You're back in the same dispute, and you've got somebody, if not the federal government, maybe it's local governments, maybe it's a government next door, saying, well, we'll put up the money.
Your question is not inappropriate. It's a very good one. And when I set out to write this draft, one of the things that I tried to do is I tried to answer this question as a matter of law. I see that maybe that was a mistake. But I think this question can still be answered on the facts, right? And so I think in this instance, the facts that we have, I think it is possible that there's a version of this draft that could be molded that says, on these facts, the United States Department of Education has not put any strings on the money, in that the money has been provided and the school district will fall where it may. And the GoFundMe money from the public, in the facts that are presented, there is no strings attached on this money in this case. It's money from the public. In our facts, nobody has put anything on, has put any influence on that. And nobody has made any explicit overtures. And then we can issue an opinion, not on the law, with a broad blanket like I attempted to do. But we could do this on the facts in this instance. And then we could do what we've done probably the last 6 or 7 opinions in a row and say, in these unique circumstances, we issue this opinion pertaining to these facts, these parties, et cetera, like we tend to do. We could do that here if you think those facts as I'm outlaying them, are the facts that have been presented by our requester. And if you agree that that's the outcome.
Further questions or discussion? Commissioner Akers.
Even though I seconded the motion, Commissioner Waldman, Commissioner Gates may have persuaded me to vote against it, but not maybe for the reasons.
Be still my heart.
But not for the reasons you might have thought. What it did is it made me more convinced that the proposed advisory opinions is correct and should be adopted. I realize politically it's more expedient to probably adopt the amendment, but I really feel like that's not very intellectually honest for me. And that is because we will not have any investigation before December that allows us to inquire or verify the motives for which a person has contributed to this third-party independent fundraising effort.
It's hypothetical at this point. The GoFundMe is hypothetical. They've been approached,
Or
but nothing.
any third-party fundraising. In fact, the proposed request, or the request that asked for an advisory opinion, specifically stated that there is no indication, as far as I know, I think this is the case, that the fundraising efforts are being made with the intention of influencing decision-making authority of a district school board member. And I think there are some previous opinions, and you can verify that said if there's no indication of anything of value that's being provided in order to influence the public officer's conduct regarding the interests of the person making the contribution, then it's appropriate.
The case that's cited, 15-13, states that in order to have a violation of 112.313 subsection 2, you need a quid pro quo. So there needs to be the overture for the bribe part.
Because that is not going to change, as far as I know. Because we don't have somebody here, or correct me if I'm wrong, we don't have a record of investigation that shows. And very frequently, again, this commission is faced with, whether it's an advisory opinion, or whether it's faced with complaints about potential violations of the ethics code, that we do not know the intentions. Sometimes we do, because we can see it on the back end. But in this case, I actually think, and this may seem extremely optimistic about the public, but there could be people that admire enough a person for staying in an office during a very difficult time. And there are circumstances that it doesn't have to be just because of politics. It could be because of some natural disaster, that someone is willing to continue to do this job. And I might support somebody or other causes, sometimes even if I don't absolutely agree with the decision being made, because I respect the tenacity or the perseverance of the person serving. And so for that reason, I think that it's inappropriate, again, for us to be looking for answers we're not going to get and using that as the basis for denying the second portion of the opinion.
Further discussion. Commissioner Carvajal.
I will start by saying it gives me great pause that it is all the attorneys that are giving advice that I seem to be opposing, and I'm worried about that. But what I study is public administration, and the reason I distinguish question 1 from question 2 is in question 1, the U.S. Department of Education is an appropriate appropriator, and this is not an unusual strategy, whether you assume block grants or strategies that have been used for civil rights or interpolation that happened in Florida. Question 1 is much clearer to me from a public administration standpoint, regardless of what the attorneys say. Question 2 is a moral hazard to me. And, the motion on the floor is to support question 1 as answered, and I'm in the posture to vote in favor of that. And all I'm saying is I would oppose number 2 every single time. There is no way that we can allow the signaling to influence votes. Elections are the only means to do that, not dollars that are collected separately.
Well stated, but again, I remind you that the motion before us does not include question number 2.
Understood.
It is just question number 1.
Understood.
Commissioner Waldman has moved, Commissioner Hankers has seconded a motion that we approve the draft as it relates to question 1, and that we postpone as to question 2. Is there further discussion?
Yes.
Commissioner Gilzine.
I just would like to use this opportunity to say that the Florida legislature should consider tightening up restrictions on donations made to public agencies, requiring clear documentation where funds come from, who exactly contributes to the funds, whether they're lobbyists, elected officials, documentation that affirms that the funds are used for the benefits of the agency, not the individuals or public officer.
Okay. All in favor of the motion before us, say aye.
Aye.
All opposed, say no.
No.
Call the roll.
Yes.
Yes.
No.
No.
Yes.
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 Just to understand the staff directive here, I will come back. Just so I'm perfectly clear. Gift, US DOE gift, we've approved that today. US DOE, whether or not it's a bribe, we've approved that today. GoFundMe, whether or not that's a gift, we've said that's okay that's okay as drafted. US GoFundMe, whether or not it's a bribe, go back to the drawing board.
Yes. Thank you, Steve. You've done an excellent job, as usual. That takes us to the next item, and I would note that we are well beyond the time to convene the executive session, but I think we're about through with the public session. I thought that about an hour ago, too. But I think these other items will go rather quickly. The next one is financial disclosure appeals. These are people who have appealed the automatic fines for failure to timely file their annual financial disclosure form. None of the applicants have requested to be heard. There are 3 in number. Does any member of the commission wish to vote separately on any of those? None appearing, then we will take them up in bank. They are before you. Is there a motion?
Move the approval of the proposed final orders with respect to the financial disclosure appeals and Moss.
Second.
Any further discussion? All in favor, say aye.
Aye.
Opposed, like sign. Show it adopted. And then we get to the uncollectible disclosure files or fines. These are all situations where there's been a final order imposing a fine, and it is recommended that we declare it uncollectible because in all of those situations, the filers are deceased. And I guess we could always go after the probate of their estates, but we don't do that. So do I hear a motion?
Move to accept the items under consideration of order declaring final disclosure uncollectible for items A, B, and C.
Second.
All in favor, say aye.
Aye.
Okay, show it adopted. That takes us to item 9, and that is a rule hearing. We have noticed for today a public hearing on the adoption of modification to certain commission rules and forms. The rules amended are 34-8.002 through 34 001 of the Florida Administrative Code, which are the rules relating to the instructions for Form 6, Form 6F, and Form 6X. The changes will update the rules to account for recent changes made by the Florida legislature in Section 1123144, including necessary changes to account for the mandatory electronic filing of Form 6, which will occur in 2022. Unless there's an objection, I'm proposing we take all of those up. These are fairly simple. What we're really doing is conforming our rules to match the necessities brought about by passage of legislation. Gray, you're recognized to give us an explanation, hopefully briefly, of what we're doing.
Thank you, Chair. I'll cut this presentation short. I just have a couple things I want to emphasize about this rulemaking. First, our goal here is not to rewrite the Form 6 rules. That just didn't seem necessary because the majority of language in the rules is going to apply regardless of whether or not someone is filing their form by paper or electronically. We just try to go through the rules and eliminate any references to filing by paper or through the mail, and then replace that with language about filing electronically that tracks almost verbatim the language in the statute. And the next thing I want to emphasize is that several of these rules incorporate by reference the Form 6, 6F, and 6X, as well as the instructions for completing those forms. We, starting next year, will no longer have any statutory authority to provide those forms or to accept them. So we propose removing the paper forms from the materials incorporated by reference. But the key thing to know here is that the incorporated material will still include the instructions for completing these kind of forms. And we've streamlined the instructions as well just to provide for e-filing. Last thing I want to draw your attention to is that the rulemaking will repeal Rule 34-8.007. That's the only rule that we're recommending repealing instead of just amending. That rule does one thing. It accommodates Form 6 filers who choose to use their federal income tax return in place of listing on their forms each source of income that exceeds $1,000. The reason we're recommending repealing it is because the legislature has done away with giving filers that choice. It's amended the statute to say that starting next year, Form 6 filers will no longer be able to use their federal income tax return in place of listing out their sources of income. So we're recommending repealing it because there's no longer any statutory authority for it. Now, each of these rule changes have been duly noticed. You can see the notice of proposed rulemaking that we published back in September, the Administrative Register. I provide all of these changes to JAPSE. I checked yesterday, they have not issued any feedback to us, which I take it to mean they're comfortable with the changes that I'm proposing here. So I would ask this morning that you approve these amendments so they'll be ready by next year when e-filing goes into effect. Thank you.
Well, thank you. Are there any questions of members of the Commission? Commissioner Wallman.
Thank you, Mr. Chair. When did the legislature do away with the being able to supply your tax return?
I believe that was when they updated the statutes. I think it was 2 years ago to start providing for e-filing.
Yeah, let me just state that the purpose of the public hearing is to allow the Commission to hear any public comment, take evidence, arguments about the proposed rules, and following the hearing, the Commission will decide whether to make any changes in response to the public comments or written materials, or whether to adopt the rules as noticed. The Commission can withdraw them in whole or in part, or make whatever changes are supported by the record of the public hearing and or any written materials that we've received. We can also make technical changes which do not affect the substance of the rules. Do we have anybody in the audience who wishes to testify or make comment? Mr. Herring, would you walk up so we can record what you have to say?
Mr. Chairman, members of the Commission, sometimes when I get up here when you guys are considering legislation or in these kind of proceedings, I say something that you guys adopt it and it turns into an idea. And this was one of the things I mentioned many, many years ago, to as a mechanism to keep people from making omissions in their forms, was electronic filing, because you see a lot of forms where people leave off addresses, they leave off amounts, they leave off this. Hopefully, this new system that you have will say, if you leave off the address, it reminds you and you need to put it in. Okay. That being said, I have some concerns about what the law and/or the rules are going to require in the future. As Mr. Schaefer noted, the legislature did away with the ability to submit your income tax form. Well, with a Form 6, you also have to report all your assets. And there are a number of Form 6 filers out there that have a substantial number of assets that they have in various investment vehicles, IRAs, stocks. And many of you may or may not know that there were members of the legislature that would submit 300 pages worth of stock information. Now, they cannot no longer do that under this rule. They are going to have to sit down and type in 300 pages worth of data on your form because they cannot submit the paper. That is going to be a tremendous burden to those public officials. And I don't think that at least my idea was that the ability of people to actually submit their financial statements as a way to deal with these issues was ever even contemplated when this legislation came into pass. The second issue that I have with the proposed rule, and it deals with candidate qualifying. As you know, when a candidate is qualifying for a constitutional office where they have to file a Form 6, they are now going to have to do that electronically when they file. That's in the rule that you guys have proposed. It's 34-8002 subsection 4. And notwithstanding the fact that you may have write-in candidates that might qualify at the last minute, legitimate candidates also qualify at the last minute. And I'm not sure that I anticipate that there will be potentially candidates that will come and try to qualify that have not taken those steps to get the electronic credentials to do the electronic qualifications. And so that's one of the concerns that I have with the rule. Other than that, I appreciate you giving me some time to respond or give you my thoughts, but those are my two concerns with the rules.
Thank you, Mr. Herron. Does anyone have any questions of Mr. Herron? Commissioner Wallman.
Thank you, Mr. Chair. So what would you suggest that we do to rectify those issues?
Well, and again, I haven't totally, well, with respect to the attachments of assets that may, again, be hundreds of pages in terms of certain people, somehow figure out a way that people can submit a PDF copy and it be accepted by the commission, okay? As opposed to sending you tons of paper, they can send you an electronic PDF copy of their brokerage statements and it be included with the other information. Frankly, I don't know how this information is going to be formatted for public inspection. I don't know the answer to that question. But the fact that you would have the electronic form and then the attachment of the assets would be the way I would think to do it. The other issue with respect to the requirement that candidates who are running for office file an electronic Form 6 as a condition for qualification, I haven't thought about it enough, and I don't know whether the law requires that particular statement. I don't know. I haven't gone back and looked at the law that was passed 2 years ago, and I apologize for that. So,
Are there further questions of Mr. Herron? Thank you, sir. Is there anyone else in the audience who wishes to make a comment? Gray, do you have some concluding remarks, or do you want to respond to? Mr.
And
Herron.
I'm very sympathetic to what Mr. Herron said. However, I'd just like to emphasize a couple of things. When the legislature updated the statutes, we tried to take that into account when we formulated these changes to the rules. We didn't create these rules in a vacuum. We tried to track the language that the legislature gave us when it updated the statutes to provide for e-filing. Sections 112.3144, subsection 6C, and subsection 7A specifically state that starting next year, we will no longer be able to accept federal income tax returns. So the rules just reflect what the legislature did when it changed the statute. Although it may make things a little bit more difficult for certain filers, we can't escape the fact that that is what the legislature has given us. In terms of the filing requirements for candidates, I think the provision in there's two provisions to look at, two statutory changes. Section 112.3144, subsection 4, sets out the filing requirements, the e-filing requirements for candidates, making it very clear they have to use e-filing and how they should file to qualify. And just a reminder to the Commission, the legislature that made these changes also made a change to Section 112.3144, subsection 2, and it stated that any Form 6 filed under Section 112.3144, whether filed by a current and serving public officer or by a candidate, will have to be filed electronically. So this is obviously kind of a seismic shift in terms of qualifications, but it's something that is in the statute. We are just reflecting what the statute says in our rules, and it's something that we all will have to become comfortable with.
Commissioner Walden.
Thank you, Mr. Chair. But what Mr. Herron was talking about wasn't filing the tax return. He was saying people have, they have lists of all of their assets, and just being able to attach that as a PDF, there's a spot to do it. I know we actually, when we fill out the things that go to the governor or whatever, you have the ability also to give a PDF to the governor. So he's not asking to say, let them file their tax return. He's saying a list of assets.
I understand, Commissioner. You know, that's, in terms of the rules, all the rules are saying is you can't attach an income tax return anymore. You know, we're not commenting on what other procedures that someone might want to do. I think your question, if I'm understanding it correctly, I don't honestly know how the e-filing system will be set up, whether it will provide for that or not, a PDF list. You know, what the rule is just saying, though, is you can no longer use an income tax return.
So then I guess the question is going to go, when you're going to give your report on e-filing, is that something that can be done? Because it does make a lot of sense. I don't think people want to go who have lists of hundreds of stocks or bonds or whatever, if they have an IRA or whatever, in a fund, that they need to do that individually. I'll wait for your e-filing report.
Further questions or comments?
Well, may I ask, Ms. Stillman, without waiting for your e-filing report, can we find the answer?
Stealing the thunder, yes.
I mean, because it might be relevant, right, to
Well,
this right now, although I understand what Mr. Schaefer's saying,
Uh,
just on that point.
Yes, just on that point. Currently, the system is not set up to accept a PDF of one's assets. The thought process behind the electronic filing was once they completed their form and clicked submit, it goes straight out to be published. Should someone upload a PDF of their assets, that comes along with account numbers and other personally identified information that would then cause that information not to be able to be searched by keyword by the public, and would also then require the commission staff to go through line by line and redact prior to putting that form out on the website like we do now. But we do anticipate that that will be a tough pill to swallow, and that the legislature, may make decisions based on their experiences there.
Okay. All right, I will accept a motion to file the proposed rule changes with the Department of State for adoption.
I'd move that.
Commissioner Meggs moves. Is there a second?
Second.
Second. Commissioner Carvajal. Is there discussion? All in favor, say aye. Aye. All opposed, no. Okay, show that adopted. That takes us to the final item under reports. As the acting chair, I have only one item to report, and that is that the governor, in his infinite wisdom, has reappointed Commissioner Waldman, Commissioner Meggs, Commissioner Cummings, and me. So you'll have to put up with us for another two years.
Only if the Senate agrees.
Well, and that's my next reminder. Remember that the legislature goes into session much earlier this year, and our appointments will be up, and there are forms that are necessary to be filed with the Secretary of State. So I think you all have those forms. If not, certainly Carrie will send them to you, but try to get those in as quickly as you can. The next item, and I'm going to turn, there are three items, and I'll turn to Carrie for all three of those. One is a legislative update. The other is a continuation of what she's already started on discussing e-filing and any other items that she has in her report.
Thank you, Chair. Briefly, for the legislative report, there are two bills that have been filed so far, one in the House by Representative Roach, House Bill 301, and one in the Senate that is identical, Senator Brodeur, Senate Bill 510. They address the filing of Form 6s by city commissioners and mayors, which is one of your recommendations that you made to the legislature for this year, so we'll be keeping an eye on those. Additionally, Caroline and I met with House and Senate staff directors for their respective ethics committees to talk about the Commission's recommendations, and we expect that there will be updates to the committee on the Commission's recommendations as well as the e-filing project during committee weeks. I have no indication as of yet as to whether or not there will be any committee bills containing the Commission's recommendations. And so, speaking of which, I know there are others who likely have some things to contribute that they might have been doing with the legislature lately. But if any of you have some good working relationships with your former peers and know of anyone who might be interested in sponsoring legislation related to our recommendations, if there's any way that Caroline and I can assist in that endeavor, please let us know. We'll be happy to reach out to their staff. And with that, I will turn it over to any other members who have anything to report regarding legislation.
Any other members want to make a contribution?
Just quickly, Mr. Chair, at Chair Lesnoff's request, I met with Senate leadership about our matters, particularly the implementation of the lobby ban section of Amendment 12. I think it's fair to say that the list of items that the Commission had as sort of a continuation of last year's list was met with mild interest in the meetings that I held. The one item that appeared to get raised eyebrows was the question of raising the limit for penalties, because our penalties had not been raised for many years. I was asked the question, how many times have you assessed a $10,000 fine? Of course, that led to embarrassing coughs all around, and in that matter, I think may have receded into the mildly interesting category. As to the implementation of Amendment 12, there appeared to be three potential options, at least under conversation. One was that a violation of the lobby ban would simply be viewed as yet one more ethical violation to be dealt with in the way that we have dealt with violations of the 2-year lobby ban. Another possibility was that this matter being a specific constitutional matter and a large number of people who voted in favor of it, that it would be immediately viewed as a criminal matter, and that a violation of the lobby ban would be turned over to the criminal authorities. And the third option that was discussed was that the commission, having the investigative experience of working with a 2-year lobby ban, would investigate and would find probable cause if probable cause existed, and would go through a penalty phase, and then refer the matter for criminal prosecution if appropriate. I didn't gather that there was a strong conclusion as to which way the Senate might proceed. I know that in the House, Don Rubottom, the staff director on the House Committee, had been asked to put together a potential approach from the House's standpoint, and that they were to brief House leadership. I think Chair Lesnoff was going to be in contact with folks in the House about that. Maybe our executive director has, and that she can reflect on it as to where that was going. I know that the House, Mr. Rubottom, was looking at definitions. If you look at Amendment 12, there are terms, some of which some people may have thought were self-evident or were already sort of worked down to their proper meaning in the Constitutional Revision Commission, but believe it or not, the question, what is the federal government? What is lobbying? There were a series of definitional questions that were at least being conversationally raised in the House, which I believe staff there have been asked to look at as part of their analysis. I think, based on what was shared with me, the House will pitch and the Senate will catch as to the ethics matter in this session.
Thank you, Commissioner. Any further comments regarding legislation?
May I would like to thank the commissioners who have given of their extra time that they don't have and talent to communicate on behalf of the commission with the legislature.
Thank you, and I would certainly agree with that. All right, the only other item is for the executive director to bring us up to date on e-filing. I would also note that in your packet that was sent out was a very well-done pictorial staff directory, as well as a directory of contact information for all the members of the commission. I have asked her to make sure that that is sent in electronic form to all of us, so we would have it easily accessible on our phones or whatever. And what, just one page or? Oh, okay. Anyway, I've asked her to do that, and so you'll be receiving that. You've just been passed out an updated information packet regarding the electronic filing. It's hard to believe we've been talking about this since before I went on the commission, and the balloon is about to go up in very short order, and that I think is a great accomplishment for us. It's going to be very important for the commission, but it's also going to require some adjustments and perhaps some increased staffing, at least initially. And I think the general public, once they learn how to do it, you know, we live in a point-and-click society now, and, you know, people, you know, are not used to filing electronically, and once they realize they don't have to fill out those forms like they formerly did, I think this is going to be widely accepted by people in Florida who have to file. And I would be remiss if I didn't express my appreciation to Carrie in particular, but also to several other members of the staff, I think who have taken up temporary residence in other offices, such as the Secretary of State's and so forth. Many hours have been put into this project, and I'm very, very proud of the product that our staff has produced. As with anything, there are always going to be a few bumps in the road, and you never know what is wrong with the car till you take it out for a spin. And that's kind of what we're going to be doing here, and there's going to be some things we have to work out. But Carrie, congratulations to you and the staff for a job very well done.
Thank you. Chair, with your permission, I'm going to take a slight detour real quick before I start the electronic filing update, because I anticipate there'll be some discussion on that. And just a brief addition to the Executive Director's report, I wanted to let you know that the opinion you issued at the last meeting related to the taxpayer rights advocate, you might recall that opinion was requested to be withdrawn. You denied that request. You proceeded with hearing the opinion request and ultimately adopted the opinion. The requestor on the last day appealed that opinion with the District Court of Appeal. So that opinion is currently being appealed in this building. Your staff is preparing the record, and the requester has 70 days to file their initial brief, which will happen sometime in December. So we'll keep you apprised of the status of that appeal. With that, let me move on to the e-filing update. What was passed out to you is really essentially what you have in your materials. We just wanted you to have a pretty hard copy to look at as I went through, so you didn't have to, like me, squint to see what's in your small computer screen. The first page that you see there does have a nice new picture of the Capitol on it, which is a recent addition that we've added. But on January 1, we're launching the Electronic Financial Disclosure Management System. We fondly refer to that as the EFDMS. The system is currently in user acceptance testing, which is why we are not in a live demo situation today. Data migration and cleanup has occurred and is ongoing. Data synchronization is being tested because you might recall that our current financial disclosure system will have to talk to the e-filing system with the phased rollout that we're doing, so we have to test that process. And the team is working to clean up any bugs in anticipation of a pilot test starting in the next few weeks that we'd like you to be a part of if you would like. Testing has been going well, and we've been fortunate to have the support of House and Senate in this entire electronic filing process. You might recall that the Office of Legislative Information Technology is heading the programming efforts up, and OLITS is overseen by House and Senate IT. And so this has been a Herculean task so far. We have some of the brightest minds working on developing this in terms of IT since the fall of 2019. And so we're excited to share with you a glimpse of what we believe will be a system that increases transparency, makes it easier for filers to properly complete their disclosure form, and to the extent that this system is a success when it launches, it will be due to the very hard work and many hours of the e-filing team downtown. Okay, in your materials are the screenshots, and we'll continually work to improve both the aesthetics and the functionality as the system as we work through testing. There are 5 types of individuals who will be accessing this system when we launch for Form 6. You're going to have the agency coordinators who provide us with the information of the names and addresses of the individuals who are required to file disclosure. We have the Form 6 filers themselves. We also have the non-incumbent, non-filing candidates. These are people who would be running for office for the first time, who do not, and/or people who do not already have a filing requirement for financial disclosure. You'll, of course, have your ethics staff who'll need to access the system, and significantly, the public. Immediate credentialing will be provided to the roughly 1,800 agency coordinators who cover roughly 4,000 organizations within government. They are key to the success of this system, and we're in the process of communicating with them, working through robust, frequently asked questions for those coordinators. There will be how-to explanations and videos about what they will be doing in the system, and Kim will be conducting some Zoom webinars in January for these coordinators. Each agency has a coordinator, and they are responsible for the accuracy and the data that feeds into our system for those roughly 40,000 filers who we see each year. January 1, those coordinators will begin logging in to update their filing lists for both Form 1 and Form 6, even though Form 1s are not filed electronically this year. This update process used to be done once a year. Beginning of each year, we would ask for an update. But under the new system, one of the biggest changes will be that they will be updating the system in real time. As people come on and leave boards or leave employment or are elected to office, they'll be noted in the system so that those individuals can have immediate access and do not have to wait. Any filer will be able to access the system starting January 1. By law, it has to launch January 1, no matter what. They'll be able to request an invitation code and set up a profile. We plan to provide filers with their access credentials in earnest, meaning a blast email to everyone and a mail out to everyone in March, because we need to give the coordinators a chance to get all of the filer information as updated and clean as possible before filers start hitting the system and adding new information to it. The first screenshot you have in your materials is the landing page where filers access the system. Officials who file Form 6 will use their credentials to log in. Candidates who currently do not have a disclosure requirement will be able to request a candidate account. The candidates will create their profile and complete the disclosure electronically in the system. They will then print their disclosure and take it to the qualifying officer. We will have instructions about that in the system for those candidates. They will not be filing electronic with the commission, but should they win election, then they will be able to log in and push that disclosure to the commission, because that's ultimately where it will land. We'll be working with the Department of State. I've already had some conversations with their Division of Elections, as well as other qualifying officers about how to communicate this change in process for these candidates and put it in the best way possible and as many places as possible. You'll note that also on the login page is a link for the public to be able to search for disclosures, as well as links to important announcements for filers and the public about the new system. Another slide provided to you is upon logging in, Form 6 filers are going to see their filer dashboard. This is their one-stop shop. It's going to give them a general overview of their filing status, allow them to begin filing their Form 6, as well as their Form 6X, which is the amended disclosure if they need to amend a form, as well as the Form 6F, as in final, which filers have to provide within 60 days of leaving office. Those are the disclosure forms that will be filed in there when we launch. Filers will also be able to view the organizations they are associated with on that dashboard. They'll be able to request filing extensions, be able to request confidentiality exemptions as appropriate, as well as see any messages we need them to know in there. On the next slide, you will see, they will have access to FAQs. If you look in the upper right-hand corner, you can see a screenshot where FAQs are viewable by topic as well as by question. And importantly, and something we're really excited about, is they'll be able to search those FAQs by keyword. As questions come in about the system, we will be able to add additional FAQs to augment that page if there seems to be information that somehow is unclear or that we have failed to mention in those FAQs on the outset. Now, once filers select to begin their form, they are routed to a page that shares some helpful information to the filer. We want them to know the system will auto-save their work, so if for some unforeseen circumstance they get kicked out or they lose connectivity, information will be saved. It also lets them know we don't want them to provide us sensitive information such as account numbers, social security numbers, and PINs. The disclosure forms do not ask for that information, and we don't want them to provide it accidentally. And the system is programmed to alert a filer if it detects that they may have entered a number series that could be that type of information. It also mentions that file attachments are not allowed in the current system. As we mentioned earlier, which will be an adjustment for filers, is that they can no longer attach their tax return in lieu of listing income. They will have to list each income source, as well as in assets in lieu of uploading a document. The system currently requires that they list out each and every asset. Estimate roughly half of Form 6 filers included some sort of attachment with the form. Sometimes that attachment might just be a simple attachment where they, rather than writing in the form, or if they had too much to put in there, they would kind of redo the form in a Word document. Others might have attached assets. Others would have attached the tax returns. This change allows greater transparency for the public. It will allow them to conduct keyword searches of completed forms. It will also cut down on the possible exposure of confidential information through the system and cut down on required redactions of information that would be confidential and exempt from public records laws. This will enable, once a person completes the form, clicks the button to file it, it will immediately publish on the Commission's website for viewing by the public. We'll be urging filers to work on their forms early and often, not to procrastinate and wait till the last days before filing their forms. Certainly there will be a learning curve, and anticipating that there may be some who are unhappy, as Mr. Herron shared, with the idea that currently is not programmed to allow for PDF uploads. All right, once the filer clicks the Start Filing button on that page, they will go to see the first screen of the disclosure, and you'll notice that at any point during the filing process, the filer will be able to securely share their disclosure with their CPA or attorney for completion by clicking the button on the top left corner of the screen. They can access instructions for the section of this disclosure they're currently working on via the Instructions tab to the left of the screen. They will also have access to a full set of instructions and at all times during completion of the form, and they will be able to print instructions if they like to follow along in paper like I do. There are tabs across the top of the screen that indicate which part of the form a filer is currently on, as well as dots at the bottom of the screen that show them their progress. They can click to save their work if they like to do that frequently, even though the system will save. They can move forward, they can move backwards within the system and note their progress in the form. They can print a draft of their form at any time. They can also print a copy of their form for the records at the end of it all, even though that won't be required because the system will save it for them. They'll be able to view past filings as well. And you'll note throughout the system there are tool tips and highlights where different aspects of the form are explained to the filer. There will be questions that are asked of the filer as they move through the form to help make sure that they don't miss anything, or reminders near the end if they fail to include information required in the form. Under the general information screen, they will confirm their information is correct and provide any necessary update. The law requires that filers keep an updated email address on file with the commission, because not having an updated email address will not constitute unusual circumstances for having a fine waived. The system will prompt filers with qualifying reminders if they have noted that they are a candidate on the form. Incumbent filers, as well as those maybe running for a new office who are already Form 6 filers, will complete the form in the system and file it with the commission, and they will be able to provide a copy of that disclosure, a hard copy, with their qualifying officer. Importantly, they'll also be able to print a verification or receipt of the filing within the system. They'll start by providing their net worth. You have screens on that. It will feature a brief explanation of what is required. There will be further explanation should they need it, as well as instructions. We'll also put at their fingertips commission opinions that have been issued about completing the disclosure form. Again, as they work through the system, the filer will get to answer certain questions that will help hold their hand as they walk through the form. The idea being similar to a TurboTax system or something like that. It will help jog their memory of what they might need to disclose, provide definitions of things, which in looking at the paper forms might have been intimidating or a little more confusing. That information will be there, as well as how to disclose that information. Once a filer has progressed through the entire disclosure, they will, if they have a confidentiality request on file with the commission, they will be able to redact certain information from their disclosure. Guidance is provided as to what information can be redacted, and the filer will simply highlight the information they wish to redact, such as the address of their personal residence, if they are a judge or a state attorney perhaps. They'll have a chance to review and approve the redactions before those redactions are applied, and those redactions will be able to be lifted by certain commission staff in the event of a redaction error, or in a case where there is an investigation where the information provided in the disclosure needs to be viewed as a part of the investigation. Filers who are not designated as confidential filers will not be routed to the redaction page. A final step for the filers will be a review page. This is their chance to look over the entire form before clicking to submit and file it. They can choose to update sections as needed if it's noted that perhaps nothing was included as a part of that section of the form. Once they are satisfied they've properly completed their disclosure, they will sign it within the system, date it, and click File My Disclosure. A pop-up box will appear telling them they've filed their form, offering the filer a chance to print the form if they'd like, and notifying them that if they are a candidate for a Form 6 office, to make sure they file a copy of that disclosure form with their qualifying officer. An email will be sent to the filer notifying them the form has been received, and filers will be able to click a button on their dashboard to print a verification or receipt of filing on demand as required in the legislation. Once the system launches, communications about their filings will be done via email, and they will have to update that email address. Filers must also be provided with a government email address to use for the purpose of this disclosure system if they wish. Communications have started. We started communicating with judges, particularly about confidentiality concerns, and we will be continuing to communicate with them, and we will start communicating with all filers with information about the system, as well as these coordinators who play a crucial role in updating the system. And we are planning to have some coordinators participate in the pilot that we run on it. And we will be continually communicating with the filers, doing video tutorials, expanding FAQs to get the word out about the system and to help them adjust to this new way of reporting their interests. And if there are any questions or concerns or further discussions that you'd like to have about the system, I welcome your comments and input.
Are there questions of members of the commission? Okay, none appearing. We're actually going to adjourn for about 15 minutes and come back, and Carrie's going to give us a pop quiz on the electronic filing to see if we pass.
Get your number 2 pencils out. We're going to do the electronic filing quiz on paper.
Well, thank you for a very good report. Is there any other business or comments that members of the commission want to bring before the public session? Okay, the time is 11:20. We are going to convene the executive session at 11:35. It'll give chance for staff to set up the electronics and so forth. And so with that, Commissioner Gilzine moves we rise.